So I'm going to tell you first about McLaurin versus Oklahoma, which is an University of Oklahoma case. So in the autumn of 1947, George McLaurin applied to the University of Oklahoma in the hopes of pursuing a doctorate in education. McLaurin knew that the laws of the state of Oklahoma forbid African Americans from attending school with whites. In 1947 in Oklahoma, educating blacks and whites together was a criminal offense. On February 2nd, 1948, in accordance with state law, the university rejected McLaurin's application. Thus began a landmark Supreme Court case, McLaurin versus Oklahoma. This case desegregated the University of Oklahoma's Graduate School of Education and promised that African American students around the country would not be excluded from public professional schools. McLaurin was an important civil rights case for two main reasons. First, it was one of the first civil rights Supreme Court's victories in education, part of a strategy by the NAACP's legal team to fight racial discrimination in the American educational system. This persistent pursuit would culminate in the 1954 Brown versus Board of Education decision. Secondly, the decision's language challenged the standard of separate but equal that had been set by the 1896 Plessy versus Ferguson case. While George McLaurin's admittance to the University of Oklahoma might seem relatively minor, it was only George who was admitted, the case chipped away at the premise that racially segregated education could ever truly be constitutionally sound. In the Plessy case, the Supreme Court ruled that states could mandate racial segregation without violating the Equal Protection Clause of the 14th Amendment, so long as they provided equally for whites and blacks. This was the birth of the separate but equal principle, which would uphold Jim Crow laws for nearly 70 years. George McLaurin knew the segregation in Oklahoma's schools well, and education was of the utmost importance to the McLaurin family. For 33 years, he had taught in Oklahoma's segregated African American schools. His wife was also an educator, and they'd migrated to the state in 1910 from Mississippi. They lived in a segregated African American neighborhood of Oklahoma City, where they raised 3 children who, like their father, all received master's degrees and pursued doctorates. McLaurin was not the first African American to sue for admittance to the University of Oklahoma's graduate schools. Ada Sipuel was rejected from the university's law school in 1946 because of her race and filed a lawsuit immediately afterward. Sipuel received her bachelor's degree from Langston University, Oklahoma's sole historically black college. Langston was called the Oklahoma Colored, Agricultural, and Normal University until 1941, when it was renamed for the first black member of Congress from Virginia. The university's existence owed to the Morrill Acts, which created land-grant colleges, including Oklahoma State University. The first Morrill Act was passed by Congress and signed into law by President Lincoln in 1862 in the midst of the Civil War. The second, passed in 1890, as racial segregation was rapidly becoming law in the southern states, declared that states receiving land-grant university funds must either admit black students or create separate colleges for African Americans. And so, in the South at least, historically black land-grant colleges like Langston University were born. But Langston had no graduate programs where men and women like McLaurin and Sipuel could pursue advanced degrees. Indeed, the University of Oklahoma was the only public institution where students could receive professional degrees in law or education in the state. Both the local district court of Cleveland County and the Supreme Court of Oklahoma refused to force the University of Oklahoma to admit Sipuel. But the United States Supreme Court agreed to hear her case. And in 1948, just months before McLaurin would apply to the university, the court ruled that if the state of Oklahoma provided a legal education for white students, it was required to do so for qualified black students too. Now, this did not necessarily mean that the Oklahoma State Regents were required to desegregate the law school. Instead, they chose to create a separate but equal law school that would be based out of Langston University. Though she technically won, the victory in the Sipuel case was a bittersweet one. Sipuel knew that the separate law school the state set up for her would never provide her with the kind of legal education that her white peers would get at the main law school. At stake was the quality of education. Surrounded by peers and eminent professors, and with access to an extensive law library and the resources of a major university, Sipuel knew that she would learn the law at the University of Oklahoma in a way she simply could not do by herself in a makeshift law school. After threatening to return to the Supreme Court, the Oklahoma State Regents relented and allowed Sipuel to attend the University of Oklahoma's law school. Sipuel's lawyers were the same lawyers that would take on the McLaurin case in 1948. The more prominent lawyer was Thurgood Marshall, who was the NAACP's head lawyer and would most famously go on to be the first black justice on the Supreme Court. Before his appointment to the court in 1967, Marshall pursued a number of civil rights cases, many of them in education. This was a strategy the NAACP started in the early 1930s. Amos Hall was McLaurin and Sipuel's other lawyer. Hall was an African-American lawyer from Tulsa who would later become Oklahoma's first elected black judge. He too worked as a lawyer for the NAACP, but at the state level. Before taking up the graduate school cases, Hall was the head lawyer for a case against the Tulsa Board of Education. Hall and the NAACP sought to equalize the pay that black and white teachers received there. Thurgood Marshall litigated many of these cases, traveling from city to city with a formulaic plan. Marshall would work with local lawyers like Hall to sue school districts that paid black teachers less than white teachers with similar experience and levels of education. The lawyers would procure the salary schedules of the district and then sue them, claiming that unequal pay for teachers violated the principle of separate but equal set by Plessy versus Ferguson, and they won every case. But this was long and exhausting work for Marshall. It involved a great deal of traveling, and each victory only affected the teachers in each individual district. It was also expensive and potentially dangerous for the teachers who sued. While they were certain to win better pay, those who stood out as leaders were also likely to lose their jobs. Once the case was won and Marshall left town, the teachers were left to deal with the consequences of challenging long-standing practices of racial discrimination. They could very easily be labeled troublemakers and targeted by those who sought to uphold white supremacy. The teacher pay equalization suits were, therefore, not an effective way to make the kind of sweeping change that the NAACP sought. But at the same time, in gaining more pay for black teachers, the suits did have a reflexive effect of making racial segregation more expensive for school districts. By stretching budgets, teacher pay suits highlighted the impracticality of segregated schools. Public education was expensive, and most of those costs, as they still are today, were paid for by local property taxes. It was simply not cost efficient for most districts to provide separate schools. By forcing school districts to equalize expenditures, NAACP lawyers recognized that they could challenge racial segregation from a pragmatic standpoint. Districts might be willing to voluntarily desegregate as a pragmatic solution to budget concerns. The McLaurin case held a similar promise. If universities stood by their refusal to allow African American students to attend their graduate schools, they might be compelled by the courts to provide equal education under the separate but equal principle, something that would be incredibly expensive and might pressure university officials into admitting qualified black students. In order to do this, the NAACP needed a model plaintiff. They found one in the person of George McLaurin, and McLaurin, in the year he applied to the University of Oklahoma, was one of actually 8 African Americans who applied and were rejected for their race. But they chose McLaurin because his nickname was Break, a name given to him by his children, who he consistently prodded patiently to wait and see. Litigation was, indeed, a great game of wait and see, and McLaurin's credentials as a longtime teacher and a father of accomplished children made him an ideal plaintiff for the case. While Ada Sipuel was unwilling to play the waiting game involved with suing the University of Oklahoma yet again, McLaurin had already had a long career in teaching and couldn't afford the lag time between trials, decisions, and appeals. His children had moved on to successful careers, and he and his wife received income from rental properties with which they could support themselves. As an older, married man, and this is perhaps the most important thing about George McLaurin, he posed no threat to those who worried about their white daughters attending schools with young black men. McLaurin was, in other words, a nearly perfect candidate to test the constitutionality of the exclusion of African Americans from graduate schools in Oklahoma. When McLaurin's case arrived at the United States District Court, it had a distinct advantage to Sipuel's, in that it came afterward. The lower court ruled that, in accordance with the Sipuel precedent, the University of Oklahoma had to provide George McLaurin with equal educational facilities. The court stated that any law prohibiting African American students from attending graduate school in the state was unenforceable. The court left it up to the university to determine what to do, and so in theory, as in Ada Sipuel's case, the university could find other ways to provide him with a graduate education without desegregating, like Ada Sipuel's one-person law school. But when the Regents did the math, they realized that it would cost $12 million to duplicate every graduate program in the state for black students. It would simply be too expensive to create separate programs and institutions for African American students. And I do want to mention that there were a lot of people at the University of Oklahoma who opposed racial segregation. So the president was on board with desegregation, but the Board of Regents was not, and that's who was making these decisions. And so the Oklahoma State Regents, with budgetary concerns in mind, allowed George McLaurin to matriculate into the PhD program in education, and he became the program's first black student. But in order to preserve the veneer of racial segregation, McLaurin was required to sit in an anteroom, which Thurgood Marshall called a broom closet, while attending classes, and he was only allowed to study at a specific table in an upper floor of the library. He was also restricted to eating in the cafeteria at a particular time and designated table in order to limit his interactions with white students. He was, however, very charitably, allowed to speak with white students while in the cafeteria line. The university was clear about that one. They were very proud. This was in line with new legislation passed by the Oklahoma State Legislature, which allowed black students to attend graduate programs with white students, but required them to be segregated within the program. McLaurin and his lawyers returned to court to challenge racial segregation at the university itself. McLaurin claimed that by segregating him in class, at the library, and in the cafeteria, the university impressed on him a badge of inferiority which affects his relationships with professors and other students. By constantly setting him apart because of his race, the university's policies made studying and concentration difficult, if not impossible, and deprived him of an education equal to white students. In order for the courts to accept that this, too, was a violation of the 14th Amendment's Equal Protection Clause, Marshall and Hall would have to persuade them that there were intangible ways that racial segregation made education unequal. And even when the professors, buildings, libraries, and even the cafeteria food were the same. Simply by requiring George McLaurin to sit in a cordoned-off area or telling him where to read in the library or eat in the cafeteria, his lawyers argued, the university impressed on him an indelible stamp of inequality. The district court ruled against McLaurin and the NAACP, declaring that segregating McLaurin in the classroom did not violate the Equal Protection Clause of the 14th Amendment. The university had done, the court said, what it needed to do to satisfy it, and the Oklahoma statutes were constitutional. McLaurin and his lawyers appealed this decision to the Supreme Court, and in 1949, the court agreed to hear the case, along with a similar case from Texas, Sweat versus Painter, which involved the admission of a black student to the University of Texas Law School. Both cases were argued together in April 1950 and handed down on the same day, June 5th, 1950, and both cases proved to be victories for the NAACP. In Sweat versus Painter, the court declared that the separate law school set up by the state of Texas, much like Oklahoma had done for Ada Sipuel, could not match the University of Texas Law School in, quote, the reputation of the faculty, experience of the administration, position and influence of the alumni, standing in the community, traditions, and prestige. And in McLaurin, the court declared that by segregating George McLaurin at the University of Oklahoma, the university handicapped him in his pursuit of a graduate instruction. As a professor of education, McLaurin would teach future educators. And by educating him and other African Americans unequally, the University of Oklahoma would create a ripple effect that would hurt future generations of teachers and their students. The university had to allow McLaurin to, these are their words, intellectually commingle with other students and professors in order to provide an equal education. The McLaurin case fundamentally challenged the notion that separate and equal could ever truly exist in education, even if the ruling only considered the question of graduate and professional schools. Indeed, the University of Oklahoma opened the door to such a legal challenge to the doctrine by providing perfectly equal physical accommodations to George McLaurin. In accepting that intangibles, like intellectual commingling, could create inequality too, the Supreme Court's decision created the possibility that any form of racially segregated education could be considered unequal. It was no secret that separate and equal was a fiction in American elementary and secondary schools, where Black students were educated in demonstrably inferior schools. But it would take a new challenge in the form of the Brown versus Board of Education case, which I will discuss next, to test how far the NAACP could push the ideas germinating in McLaurin. Thank you.
Freedom 101 is made possible by generous support from the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.